want to welcome you all to today's session, our friends from Keuka College and everybody beyond, those joining us from the JGUA network and adjacent. Thank you for being here. Before we get started in today's session, I wanted to tell you a little bit about John G. Ullman and Associates, and then a little bit about our presenters that have joined us today. John G. Ullman and Associates was founded in Corning, New York in 1978. We service over 950 clients and just over $1 billion in assets under management from those clients. We've been providing service in the areas of financial planning, investment management, and beyond for more than 45 years to clients nationwide. We are headquartered in Horseheads, New York, with branch offices in Corning, Rhinebeck, New York, out in the Hudson Valley, and our most recent newly opened office in Charlotte, North Carolina, that was opened in October of 2023. We are a registered investment advisor that is registered federally with the Securities and Exchange Commission. And to introduce our presenters today, first I'd like to introduce Judy Palumbo. She's one of our senior advisors, has been a member of the firm since May of 2010, a certified financial planner, and holds a Juris Doctor degree, and practiced law for 15 years before joining the firm as a financial advisor. So Judy, thank you for being here today.
Happy to be here.
And then I'd also like to introduce our second financial advisor joining us today, Leyah Dauber. She is an associate advisor and has been a member of the firm since June of 2023. She is pursuing her certified financial planner designation and is the co-host of the bi-weekly Share the Wealth podcast. You can find that on the JGUA YouTube channel, all of our social media outlets, or wherever you listen to podcasts. Leyah, thank you for joining us today.
Thank you.
And before we go ahead and get started with today's session, there is a brief disclaimer that we have to go through before getting into the information today. The information discussed in this presentation is current as of the date noted and is for informational purposes only and does not intend to address the financial objectives, situation, or specific needs of any individual investor. Any information is for illustrative purposes only and is not intended to serve as investment, tax, or legal advice, since the availability and effectiveness of any strategy is dependent upon your individual facts and circumstances. Results will vary, and no suggestion is made about how any specific solution or strategy will perform in reality. And with that, I will stop sharing my screen here, and we will go ahead and actually jump into the information that we're going to cover today. One thing before we get started, as I promised, we're going to go through the logistics on how we're going to ask questions today during the open Q&A session that will happen at the end of today's session. We do ask that you keep your mics muted and your cameras off for the duration of today's session. If you are not one of our presenters, we ask this for the purpose of the recording, but we will give you an opportunity to ask questions using our chat feature. So you will see a message in there from JGUA representative. That's Amelia Morris, a member of our marketing and communications team. She'll be monitoring the chat throughout today's session, and we'll make sure that any questions that come through do get relayed to Judy and Leyah. We do ask, if possible, that questions be held until the open Q&A session, as your question could already be covered, as we did have several questions submitted as part of our registration process, and your question may also be answered through that process. So we do ask that you do hold questions until the open Q&A session at the end, where we have designated time for that to happen. So with that, we will jump into our first question for today's session, which will go to Judy. So Judy, what are the key components of a comprehensive estate plan, and why are they important?
This is such a great question. So first of all, I want to welcome everybody, say hello, and it's nice to have you with us today. This question really encompasses, it's such an important question because an estate plan is not one or two documents. I think it's 4 documents, and I'm pretty sure I'm correct with that. but not everybody agrees. Sometimes people go out and they might pick up a power of attorney from Staples or a healthcare proxy from their medical provider, but they don't have a complete package. So there are four main documents of a solid estate plan. The first two I'll discuss, which I just mentioned, are useful during your lifetime. And so these are part of the estate plan because it does help you move forward with what your ultimate goal is going to be and taking care of you and your family and what happens after you pass away. So a power of attorney is a very, very important document. It names an agent or agents to sign your name to documents. Things like contracts, maybe to buy or sell a house, to pay your bills, the most simple example we can have, to sign checks, to maybe sign actually a driver's license, to an authorization for a child to have a driver's license. There's all kinds of crazy things that you can use a power of attorney for. The power of attorney is effective when you have capacity and you can sign yourself. And it doesn't sound like you might need a power of attorney if something happened during your lifetime and you have capacity and you can sign. But this is an actual example that I was part of. A long time ago, there was a cruise ship that ran aground in Greece. It hit a sandbar or something, and I had clients on that boat. And we were able to transfer money to them. The key thing was they were on the boat for a long time. They needed more money transferred to them. However, that was being handled at the time. And the power of attorney agent was just able to go to the local credit union and transfer money for them. And so that worked out really well. If something happens and you're on vacation, like maybe a small tree falls on your shed or your garage, you can talk to your agent, and the agent can hire a contractor and pay that bill. And maybe you're traveling out of the country, so it's more important that you get something like that fixed right away. When you do not have capacity, the part of a power of attorney that kicks in is it's called a durable power of attorney, and it means that there is no permission from you given to do whatever the power of attorney agent needs. You are in a state of incapacity of some type, and your agent can just act as though they're acting in your shoes for you and taking care of your business until you pass away. And that's very important for things like people in skilled nursing care homes, somebody who might be in the hospital for a long-term illness, sometimes treatments for cancer, other things. And so the durable power of attorney and the regular power of attorney are one document. Sometimes they have durable power of attorney in the title, sometimes they don't. So that's just a little information about a power of attorney and why it's important to have them. And I highly recommend people get them for their 18-year-old students who may be going off to college or going off to a job or a trade school. This is an instance when one or two of these documents makes sense for a very young person if they don't have an assets which to transfer through a will. But they should have a power of attorney because now they're adults and they need to name agents to take care of their business, just like we need at our ages, because you're no longer their guardian and their caretaker once they reach age 18. If something were to happen to somebody who's over age 18 and they don't have a power of attorney, or the next document that we'll be describing, which is a healthcare proxy, then you need to get a legal guardianship for your adult child. And that's very costly, very emotional situation, and it takes a lot of money. It's very expensive legal fees. So it's just a side note there. The next document is the healthcare proxy. This also names an agent. And in this case, the agent is making your medical decisions for you only when you have no capacity to make your own medical decisions. Sometimes agents are used in simple medical procedures. Somebody might be under anesthesia, a parent or a sibling that you have might be under a simple medical procedure, and the surgeon just has to step out and ask you or tell you that they need to change gears and get your permission. That is an instance where everything is fine and ends up happy. But on a more serious note, the agent can have the authority to withhold, withdraw, or remove life sustaining treatment in the event of a terminal and irreversible condition that is only prolonging the process of dying. And you don't have to have that clause. That clause is optional, but if you don't have it, life support cannot be removed. So those are the first two documents. They are used during lifetime, and once the grantor passes away, they're no longer effective. The next two documents are documents used after your death. Many of you may not have heard of this form. It's called a disposition of remains form. This allows you to name an agent to direct your funeral in the way that you've stated on the form. It's something that funeral directors really lobbied for in New York State, and it went into effect about 20 years ago. And in my experiences, families have been very, very grateful to have this form filled out by their parents so that they can manage the way the parent wanted. The purpose of the form is to guide your family at a time when emotions are very, very high and they might not know what you want. Many people never talk about this topic, which leaves it up to family members to decide. Some families really struggle with that, not knowing if they're making the right decisions or choices for their loved one, or they argue over what to do. This is a freestyle form where you state what your wishes are for your remains. You can have green burial, you can have a traditional burial, cremation, you might want a formal religious ceremony. You might also prefer a basic memorial service in a funeral director's building. You might not want an obituary. You might want one with a photo. You might not want one with a photo. So all of these things can be stated, and it makes it easier for your family and the funeral director to know exactly what you want and how to implement it. What happens when you don't have a disposition of remains form is the closest of kin in the family get to decide for you. And if you have 6 siblings and 5 of them say dad wants cremation, and one person says I don't agree, I think they want a burial, the funeral directors will err on the side of caution. I don't know how they do this. I don't know if they have to legally. They will go with a funeral. Again, I'm not sure why that is, but all the funeral directors that I've ever spoke to said we have to go with the funeral. We cannot go with the cremation if one person disagrees with the rest of the family members. So that's very important. It's also important in cases where you might be somebody who has had a partner for decades and you've had children and you've raised your family and your partner knows exactly what you want and you pass away. You are not married, so you're not closest of kin. Your family can then step in and do things that maybe you didn't want to do for your arrangements. So it is a good idea to have this. Some families don't need it. Everybody gets along and they know exactly what they want. Parents are open and discuss things like this, but a lot of people do not do this. And on a side note, you can plan your own funeral long before you need it. So you can prepay for the funeral. You can select the kind of casket. You can write your own obituary, select the church or the funeral director of your choice, which takes the burden off the family. I highly recommend doing this. The funeral director puts the payment in a bank account in your name for the specific purpose of your burial funds. It is very safe and it earns an interest, a nice interest rate, not 0.1%. And it's a highly recommended thing to do. And the last document is Oh, the last will and testament. We'll be going into this document in much more detail with the various questions we've received. So I'll end the document portion here, and we'll go on to the next question.
All right, so we will now pop into our second question of the session. This one will go to Leyah. How often should I review and update my estate plan, and what events might trigger the need for an update?
Yeah, Ryan, so this is a really great question as well. If you currently have already constructed your estate plan and you're happy with it, then we would recommend you looking over it every 5 years. A tip that we have for you is to pick a memorable event, maybe an anniversary or a birthday, maybe the beginning of the new year, that you'll take the time to look at your estate plan and make sure that there are no updates needed, or maybe that there are. Some instances in which a event might trigger for you to look at your estate plan is getting married or remarried, having children or grandchildren. Maybe your children have just turned 18, and as Judy had mentioned, creating their own will for them, or healthcare proxies or power of attorneys. Maybe your adult children are now a little bit older, mid-20s. They're able to take on more of that responsibility of maybe being the executor or executrix of your estate plan. Or maybe one of your spouses is currently looking to go into a nursing home care, and Medicaid might be an option for them. However, there are some asset requirements to qualify for Medicaid, so consulting with an attorney regarding the estate planning process for this would be recommended.
All right, so we will pop into question number 3 here, and this one will also go to Judy. How do you structure disbursements of the estate over time? Is it better to use a percentage each year or set a dollar amount?
Yeah, this is a good question as well. And by the way, we did receive a large number of questions. We're so happy to get them. And you might see Leyah and I looking down or around. We are working off notes that we prepared, because these topics are so big that we could really go on for a couple of hours if we wanted to easily. But we're going to stay on task to answer the questions thoroughly so that everybody gets their information that they're looking for. And then, at the end, like Ryan said, we can answer additional questions. How you structure disbursements of the estate over time, it's a process that you would do through the will, of course. You can put any terms in the will that makes good sense for your family. The way you would do in most cases, if there's no need for disbursements over time, you can simply have a trust or a will that says, give all of my estate to my two children in equal shares, and they're older and they're well set for each other, and they know that they're responsible adults, and that's it. And the estate can be distributed after it's gone through the probate process, and you don't need disbursements, right? When you do need a disbursement might be when one of your adult children actually has children of their own. So you might have grandchildren. And in that case, if you want the grandchild to get his or her share when they're older, but maybe they'd be inheriting when they're younger, maybe 10 years old or 15 years old, then you would create a testamentary trust within the terms of the will. These are the best way, the only way really, to distribute over time and with an end date. And they're just simple clauses in your will. A few paragraphs, and you can have a disbursement that starts once the trust is funded. So that's after the child's share from the estate, the grandchild's share. Let's say it's $50,000. The executor distributes the $50,000. And it goes into a trust that is created in the will. And the trust terms might say something like, the trustee can use the money in the trust for general care, support, maintenance, college, healthcare, education, and general support. It's generally the terms. And it might say until the child reaches age 18. And then the trustee can only make disbursements for something like college expenses. And then maybe it hasn't been used up. Maybe this was years ago and everything was cheaper. But that $50,000, there's still some left after the child goes to college. And now you have a young adult, and the terms might say, stop paying until the child reaches age 30. Let them go out and work and earn a living and start a 401k and learn how all that feels and what that takes from themselves to get to that point. And maybe at age 30, the trust might say, all right, this is just an example. I want the beneficiary at age 30 to receive 25% of the balance of the trust. And at age 35, I'd like them to receive 50% of the balance of the trust. And at age 40, they can receive the entire balance of the trust, at which time the trust closes. So that's a very simple example of how we would use disbursements over time. And the trust states the beneficiary, who the trustee is, the age that the beneficiary can start receiving payments from the trust, the purpose of the payments, as I described, and an end date when the trust is fully distributed and closed. Reasons to make distributions specific for specific reasons in distribution ranges might be college and healthcare costs, or you can distribute starting a particular age and pay annually, or in increments such as I described every 3 or 5 years. I once had a client who decided that his adult child was not going to receive his inheritance until he was 59 years old. And the reason being is that the adult child had a job, supported himself, but he never made enough money to put into a 401k plan. So the parents decided that they were going to leave their inheritance in trust so that the adult child could use the money when he became to retirement age, because he had no other savings and he would just be living on Social Security. I thought that that was very creative, and it was a great gift. And the young man, or the man, he did reach age 59, and he's still using that trust as far as I know. So the reason for disbursements are over time. Gifting to your children of minority age or college age. If you have adult children that are getting married, it gives them time to show responsibility, have their own children. You may have bequests for your children, but you may want to provide for grandchildren over time as well. And what age is best? That simply depends. Like the age that I just said at 59, you can have your own reasons and do whatever you want to, because the terms of the will are exactly what works for your family best. But some things to take into consideration are maturity of your young adults, your young adult children's, the ability to support oneself, whether or not they have substance abuse or if they're special needs children. Stipulations for all of these can be written very specifically and clearly in the paragraphs of the will. And lastly, trustees are named to manage the trust assets. I recommend that you have a trustee old enough to make good decisions for the beneficiary, young enough to live long enough to see the trust through to its end date if possible. People will have successor trustees named as well in case the first trustee is not able or willing for some reason to manage the trust. And it should hopefully be somebody that knows the beneficiaries well enough to make good decisions for them. Sometimes people decide to use corporate trustees, maybe a bank trust officer, instead of family members as trustees, because sometimes the decisions to say no, you can't have money out of the trust for what you're asking for, can cause a real divide in families. So some parents like to take the family members out of it rather than asking an aunt or an uncle or an in-law to be a trustee. They do go with bank trust officers. So that is an option as well.
To follow up on that, Judy, we have another question for you how do you enable flexibility for the executor to make judgment calls?
Okay, the executor doesn't have much flexibility at all. The executor is a fiduciary and is bound by New York State law, if you are in New York State, to make all distributions according to the decedent's last will and testament. So the executor is appointed by the Steuben here, by the county surrogates court here at B. Steuben County. Sometimes people are named in the will to be executors, but they don't really qualify. There are some reasons that you don't qualify to be an executor. Some of them are you must be age 18 or higher. You must not be a felon. Whoop. Excuse me, my camera just fell a little bit. You cannot be have ever been convicted of a felony. You can't be a substance abuse user or an alcoholic. And you must have capacity, and you can't be in jail, currently in jail. So those are some very definitive reasons that people cannot be an executor. And those things really have to be vetted out by the surrogates court. So there are surrogate court laws that the court has to follow through the entire probate process to ensure the executor is on track and following the rules for collecting assets of the decedent, paying all the creditors what the decedent owes them, paying income taxes, creating a final accounting, and then finally making distributions of the balance of what's left to the beneficiaries according to the terms of the will. So in that regard, there's no flexibility. The estate ending process is that the executor files an accounting of all estate transactions with the court. That's every dividend payment, every interest payment, all the taxes paid, all of the bills paid from the estate to creditors. The beneficiaries receive a copy of this accounting, and they also have to approve it before the distributions are finalized. It's a very formal process, and it's in place to ensure that the beneficiaries received everything that they're entitled to. Where flexibility comes into play, however, is if a trust is created within the will to distribute over time. As we've already discussed, the trustees do have flexibility in saying, yes, we can take money out of the trust for this purpose, or no, we can't, guided by the language in the trust. The most flexibility exists if the trustee has sole and absolute discretion authority to make distributions. That is a very broad allowance for the trustee to actually say, I'll give you this money for the 2 motorcycles you're asking me for. And the trustee can say, nope, we're not giving you money for that sort of thing. So that's where flexibility comes in, and there's a little flexibility regarding personal property. Personal property has its own issues. So we're talking about personal property items like antiques, jewelry, artwork, tools, furniture, etc. People fight over stuff like that. Most families get along, they can work it out, who gets what, but some really have, these are generally sentimental items, and it's very important that somebody is in a position to either make all the decisions on who gets what and works through it. Maybe it's the person in the family who gets along best with all the other siblings, and they can help the family figure it out. Sometimes a parent will do that, give it all to one child and let that child figure it out with all the other ones. Parents also can create wish lists. And the wish lists should be written in handwriting so that we know it's really from mom or dad. And in my experience, I think that the handwritten letter or list, it has more meaning than a typed letter that the parent might sign. And it means that it really is what this parent wanted. So that's another place where there's some flexibility. But regarding distributions from the estate, there is no flexibility.
Okay, and our next question will go to Leyah. How can I minimize estate taxes for my beneficiaries?
So to begin with this question, we just want to reiterate that estate taxes are different from income taxes. Estate taxes are what are paid at the time of the transfer of the assets after someone passes, and then income taxes are paid typically on the income earned by the individual. The estate tax rates and the exemptions are different than the income tax rates and brackets, so that's just something to keep in mind. However, estate taxes and gift taxes do go hand in hand with each other, so we'll talk about that a little bit more. You have the ability to gift during your lifetime or after one has passed away. Gifting during your lifetime, though, does have some annual exclusions that will apply. Currently, for 2024, you can make a gift up to $18,000 per person without having to file an income tax return. If you go over this $18,000 for 2024, you'll have to file a gift tax return just to record that the amount was gifted. You're also able to gift through your estate, such as a will or a trust, after the time of passing. There is an exclusion on this as well. It's the lifetime exclusion. And for 2024, that is about $13.6 million per individual or $27 million per couple. There is a possibility in 2026 that this legislation will sunset and could go potentially down to around $6 million or more. That's something that's to be determined in 2026. However, the vast majority of people usually don't have to worry about this, exceeding the exclusion and paying the estate taxes, because it is so high currently. But moving forward in 2026, this is something to keep an eye on. However, if you do fall in this situation, then the executor or executrix is responsible for paying the estate taxes at the time based on the estate assets. However, if you would like more information on this, this is a conversation to have with an attorney or one of our advisors here, so definitely reach out for more information on that.
And to follow up on that, Leyah, we do have another question for you. What options are available for charitable giving as part of my estate plan, and how can I maximize the impact of my giving?
Yeah, so if you're charity minded, it really is a great thing to do. And if you want to make a big impact with the charities, there are a few options that you can do. The first one would be listing charities directly as a beneficiary of your IRA. You're able to do this, and charities will receive the money income tax free. If not, then the money might be left to your children, and to take into account that the income that they're already maybe earning from their job, they will have special requirements for the withdrawals of this money that they're inheriting. This could increase their taxable income each year, so that's something to keep in mind. Maybe giving it to the charity would be a better option for you or your family. You're also able to name charities in your will. You can do this by listing a specific amount that you want to go to the charity or a percentage. Then after the percentage or the specific amount, the rest would go to your other beneficiaries, such as your children or your grandchildren. And this is all something that you can adjust during your lifetime, so it's not just a set and forget. It's usually just as simple as revising your will and meeting with your attorney. You're also able to create charitable trusts that are designed specifically to go to the charity while you're still living. The taxpayer would receive an income tax deduction for the charitable gifts, and then the rest would go to the charity at a specific future date or the time of the passing. Typically, this is more expensive than creating a will, though, so that's something to keep in mind. You also are able to gift highly appreciated long-term stock. So instead of selling the stock and paying capital gains tax rates, you're able to gift the stock to the charity, and you're able to take this as a deduction on your tax return. However, keep in mind that if you're not going above the standard deduction, this might not be something that qualifies for you, since the standard deduction is a little bit more typically, unless you have multiple charitable gifts to write off, maybe some estate or property taxes. So this might not necessarily be the best for your situation. It's something to look at and consult with a tax advisor. Just an example to reiterate the impact of gifting the long-term stock, though. If you had bought Amazon, for example, in June of 2011, it was at $10 per share. And in April of 2024, that had reached $180 per share. So instead of paying the capital gains tax rate on $170 per share, you could be able to donate that stock and take the deduction as a taxpayer on your return.
Okay, for this next question, we are going to bounce back over to Judy. What strategies can I use to ensure that my assets are distributed according to my wishes after I pass away?
The only way is by taking action. Schedule an appointment with an attorney to develop the necessary documents for your estate plan. Review different life scenarios that might be in the future for the family. Think about things like your children predeceasing you and who will get their share. Will it be siblings? Might it be a grandchild or grandchildren? These are hard things to think about, but it will result in a more complete and thoughtful plan that will assist and benefit your family for potentially decades. If you haven't created a will, you can take important measures to distribute some or most of the assets very quickly through other means than a will. You can name beneficiaries on various accounts: IRAs, 401ks, life insurance policies, health savings accounts, which I just learned about, I think, this past year in 2023. I didn't know. So as soon as I found out, I opened up our HSA account and I added my kids as beneficiaries. You can add your family to as beneficiaries on bank and credit union checking and savings accounts, including CDs. But you have to make sure that you tell the bank that you want the CDs included because they are considered separate accounts from checking and savings. And also on major brokerage firms. Not many people know that you can have a payable on death account or a transfer on death account for your brokerage firm assets, the ones that are not retirement accounts. The beneficiary for IRAs, the form and the process is different than it is for individual brokerage accounts. But that is very possible to name people to get the brokerage account after you pass away without having to go through probate. And you can also have joint accounts. Instead of naming beneficiaries, you can simply add a child or a sibling on a joint bank account with you. Just keep in mind that if you have multiple children and a joint account is opened in only one child's name as the joint owner, the funds at your death will go to that child only. Frequently, these accounts are considered by everybody involved a convenience account. You name the first adult child, or because that's the person that makes sense, as a joint owner on your bank account so they can help you if you need help writing checks and paying bills and things. But when you die, that child inherits that account. So you have to be very careful about everybody understanding if this is the situation, that you would want that joint money being shared with the other siblings and how you go about that. And that all happens internally. It's family conversations. But those are ways that you can distribute to your family without going through a will and the probate process. And as a side note to that, you can deed your real property to an adult child or children. And I do say adult because if you're under 18 and you do deed a property to somebody who's 16 years old, maybe thinking that they'll be 18 soon, it voids the deed. So you have to wait until the person that's receiving the property is 18 or older. And you can retain life use for yourself within the terms of the deed. This is a little outside the scope of this particular discussion, but it does avoid probate and the necessity of the will for real property if that is a direction that you would like to go with it. This must be considered very carefully as there can be drawbacks from doing that. Consultation with an attorney is highly recommended if you are going to use deeds to transfer your property.
Okay, so next question. This one will go to Leyah. What role does life insurance play in estate planning, and how do I determine the appropriate coverage amount?
So the need for life insurance will change throughout the years typically. As you begin the different phases of life, it might look a little bit different. So at a younger age, you might need a little bit more life insurance to supplement any loss of income that your family might endure, to pay off any debts that you might have had, maybe to plan for college expenses for children, or even just to cover the funeral costs entirely. As you get a little bit older, your children grow up, you hopefully won't have as many debts that you have to pay off. You're starting to accumulate your own assets, and you might adjust that amount of coverage to have a little bit less or just have no insurance at all, depending on your situation. When using it as an estate planning tool, life insurance can be in addition to any other financial or real property assets that are going to be inherited. It is what is going to be left to your beneficiaries. So if that is a substantial amount of inheritance that you're planning to leave, that might be particular to your situation. However, as mentioned, the minimum goal to have for the life insurance would be to leave your beneficiaries and survivors debt-free. So that would be using the life insurance proceeds to pay off any of your debts, such as your mortgages, student loans, credit cards, car loans, anything to ultimately allow your beneficiaries to be debt-free.
All right, so we're going to take a pause here for just a second. We are heading into our 9th and final question of today's session before we enter the open Q&A portion of today's Lunch and Learn. So I did want to give everyone a chance to start to think of any questions that they might have as we head into that, into our final question of the pre-submitted variety. And as you can see today, a ton goes into the estate planning, legacy planning process. It is a huge topic that, like Judy said, we could spend 2 hours covering just base level topics on this. So I did want to share quickly, bring the slide deck back up here. As part of preparing for the estate planning process and all the things we've covered today, there's a ton of information that goes into this. And if you would like to discuss your specific situation, needs in the estate planning process, legacy planning, and otherwise in what we've covered today, and you'd like to speak with either Judy, Leyah, or another member of our financial advisor team, you can see our contact information there on the screen. You can email info@jgua.com, call 607-936-3785, or visit jgua.com. Our slogan around the firm here is that we like to be here for everything your money touches. And the estate planning and legacy planning process certainly is a huge part of that offering here at the firm. So with that, I'll leave that up on the screen for anybody that would find value in that. And again, we'll get into the last question here before we open up the open Q&A portion of things. So this is a two-parter, the first part going to Leyah and the second part going to Judy. What are the differences between a will and a trust?
So we've talked a little bit already about a will, but a will is more flexible typically than a trust, and it could be less expensive. It usually can just be changed by a visit to your attorney, and it is effective for decades without ever changing it unless one of those situations that we had discussed earlier comes up, and then you should take the time to review it. The intention of the will is to pass properties to your beneficiaries according to your instructions. It can remain confidential to your family members until you pass away or until you make the decision to let them know. However, the will is a public document and will be recorded at the surrogate's court, so keep that in mind. Although that you have a written will, probate still might be required, which will result in probate and attorney fees. However, the will will set as a guide during probate to help ensure that your instructions are fully met. The assets that controlled under the terms are technically probate assets, so that is why that probate still might occur with the will. Non-probate assets are the ones that we have spoken about before, where you're able to list with the joint title, such as the joint owners on bank accounts, beneficiaries listed on your IRAs, or transfer on death accounts. The court typically does not get involved with those assets. They would just transfer as they are titled. And the distribution process that occurs is when you would pay those estate taxes that we talked about. The executor will have authority to go through the estate process and pay the taxes based on the estate assets. And as I mentioned before, it's a little bit cheaper to go with the will versus creating a bigger trust, and the expenses during the distribution of the estate might be minimal. However, Judy is going to get into a little bit more on why a trust might be better suited for you.
Okay, so a trust document is intended to last a very long time, like a will, but a trust is not something you'd run to your attorney and change 6 months after you created it, generally. Whereas a will, you have time to think about it and you can quick go to your attorney and change it, and it doesn't cost that much, and it's quick and easy to do. The trust has the same terms as the distribution of a will does, because what you're doing is you're replacing the will with something that you can control during your lifetime, and then your successor trustee, you will have a successor trustee who will then, after you pass away, distribute all of the assets from the trust without having to go through probate. That is the big draw for trusts. The other draw is that a trust is not a public document. Because estates go through the probate process and the will is on record at the surrogate's court, it's available to be seen by anybody who looks for it. However, a trust does not go through the court system at all, assuming everything goes, relatively easy and there's no arguments and nobody brings a legal matter against the trust. A living trust is created by a grantor or grantors, if there's a couple, while they're still alive, and they can own their trust. They're their own trustees during their lifetime, controlling all the assets that they put into the trust. And how that happens is to hold assets in a trust. All of the bank, assuming you have bank assets, you might have brokerage accounts, you might have a house and then a vacation home. They all must be titled in the name of the trust formally. So whatever Jane Doe owns, when she converts it all into a family trust, the Jane Doe Family Trust, all of those accounts and deeds have to be changed into that name. And that's handled formally within the banks and the credit unions, and the attorneys are involved to change the deeds, making it a little bit more expensive. But what happens is the trustees control all of that during their lifetime, just like they did before they changed the title of the assets. And then if something happens to them, there's an automatic transfer of control to the successor trustee, whether it's at a time of incapacity or at the time of the death of one or both of the grantors. And trusts can be revocable or they can be irrevocable. A will is always revocable during your lifetime. The purposes for irrevocable trusts are generally to make gifts to somebody else that you have funded, and you can't take that money back. And that makes that a complete gift during your lifetime through an irrevocable trust. Those are a little complicated and, again, outside the scope of what we have time to discuss here, but they are available. So as you've heard a number of times already, I think trusts avoid the probate process, but there may still be a probate for assets that didn't get titled into the trust. So that is a very usual occurrence. Things like a car, a bank account, a CD that was opened, maybe a high yield savings account. Just some things may not have been titled in trust, and it's enough in value, market value, that the trustee or an executor would have to go through a probate process, as well as handle the trust distribution after a parent dies, for instance. So the legal fees for creating the trust at the front are more expensive than a will. The assumption is that they can be fewer in the end when you're distributing the trust. But that only happens if you can really avoid the probate process and all assets are in the trust title. The other interesting thing is that it's not unusual for successor trustees to get professional help because they have never managed a trust before. They just don't know how to do it. So they'll hire professionals. They'll hire attorneys, accountants, financial advisors. very likely will be utilized to create additional fees. So my last note to everybody on this topic would be that fees should definitely not be the main consideration in setting up the right estate plan for your family. Your family should have the benefit of professionals who will help them get the estate or trust or both settled smoothly and efficiently. Being able to do that is what the real gift is to them.